Good evening friends, you are most welcome to Civil Affairs channel. Today we are going to discuss Vision IAS updated classroom study material for UPSC UPPSC prelims 2024-25. This is from 2024 January to March 2024. Let us begin the topic. Our topic is electoral bond. This is the topic which is under elections electoral bond scheme. Let us begin the topic. Why in the news? Supreme Court in Association for Democratic Reforms and ANR versus Union of India and ORS unanimously struck down the Electoral Bond Scheme EBS. Electoral Bond Scheme EBS electoral bond means a bond issued in the nature of promissory note which shall be a barrier banking instrument and shall not carry the name of the buyer or payee. Features of electoral bond issued to the purchaser on the non-refundable basis, could be purchased by any citizen of India or a body incorporated in India from authorized branches of the State Bank of India, that is SBI, could be used for donating only to the registered political parties which secured not less than 1% of votes polled in the last general election to the Lok Sabha or a legislative assembly. The rationale of the scheme was to enhance transparency in electoral funding since electoral bond transaction can only be made through legitimate banking channels. Each electoral bond has a unique alphanumeric number visible under ultraviolet rays. Changes in political funding in India with Finance Act 2017. Subject: laws amended by Finance Act 2017 and comparison between before Finance Act 2017 and after Finance Act 2017. First subject is corporate contributions, section 182 of the Companies Act 2013. Before Finance Act 2017, political contribution by a company in financial year shall not exceed 7.5% of its average net profits during the 3 preceding financial years. Required companies to disclose political contribution in its profit and loss account along with particulars of the total amount and of the name of the party. After Finance Act 2017 omitted the cap on corporate funding to political parties, allowed any company incorporated or established in India to contribute via electoral bonds, only required disclosures of the total amount of political contributions and not the particulars of the amount contributed to each political party. Next subject is curbing black money, section 13A to the IT Act 1961. Before Finance Act 2017, political party to maintain a record of voluntary contribution in excess of 20,000 rupees along with the name and address of the contributor. Political party to maintain a record of the voluntary contribution in excess of 20,000 rupees along with the name and the address of the contributor. Cash mode for the political donations allowed for individuals. After Finance Act 2017, political party is not required to maintain a record of contributors or contributions from electoral bonds. Donation in excess of the 2000 rupees must be received only by a check, bank draft, electronic clearing system or through electoral bond. Another subject is transparency, section 29C of the RP Act, Representation of the People's Act 1951. 17. Political parties to report on all contribution about 20,000 rupees to the Election Commission of India. After Finance Act 2017, parties will not have to submit records of electoral bonds received to the Election Commission of India ECI. Related news: political parties and income tax. Recently, Income Tax Department has raised a demand of 210 rupees in penalties from national level political party for discrepancy and delay in filing the returns. Section 13A of the IT Act 1961 exempts political party registered by Election Commission under Representation of the People Act 1951 from paying income tax. For exemption, parties must fulfill some conditions including maintaining books of account and other document. Their accounts are audited as per the law, etc. However, under Section 139 4B of the IT Act, political parties are required to file their income tax returns if their total income before exemptions under Section 13A is higher than the tax exemption threshold. Next heading is municipal election. Why in the news? The Supreme Court recently nullified the outcome of the Chandigarh mayor election, exercising its power under Article 142 of the Constitution to ensure complete justice. About municipal elections, elections for the municipal corporation are held as per the Municipal Corporation Act framed by the legislature of the respective state government, whereas elections for the municipalities and the town panchayats are held as per respective municipal act. Constitutional provisions related to municipalities. Composition of municipalities Article 243 are all the seats in a municipality shall be filled by persons chosen by direct election from the territorial constituencies in the municipal area. For this purpose, each municipal area shall be divided into territorial constituencies to be known as wards. Reservation of the seats, Article 243T. Seats are reserved for weaker sections, scheduled caste and tribes, women, and other groups as per respective municipality or municipal acts. Not less than one third of the total number of the seats reserved shall be reserved for women belonging to SC and STs. Duration of municipalities Article 243U 5 years from the date of appointment for its first meeting. Elections to be constituted. Election to be constitute a municipality by required to be completed before the expiration of the duration of the municipality. Election to constitute a municipality are required to be completed before the expiration of the duration of municipality. If the municipality is dissolved before the expiry of 5 years, the elections for constituting a new municipality are required to be completed within a period of 6 months from the date of its dissolution. A municipality constituted upon the dissolution shall continue only for remainder of the period. If dissolved municipality tenure is less than 6 months, it shall not be necessary to hold any election for such period. State Election Commission Article 243ZA. The superintendence, direction and control of the preparation of electoral rules for and the conduct of all elections to the municipality shall be vested in the SEC, State Election Commission. About Article 142 Article, Supreme Court in the exercise of its jurisdiction may pass such decree or make such order as it necessary for doing complete justice in any cause or matter pending before it. Article 142 Supreme Court in the exercise of its jurisdiction may pass such decree or make such order as is necessary for doing complete justice in any cause or matter pending before it, enables the Supreme Court to exercise executive and legislative functions in specific scenarios, including issuing guidelines, directives, or orders to governmental bodies or other authorities, permits the Supreme Court to intervene in matters concerning public interest, human rights, constitutional values, or fundamental rights, safeguarding them against any form of violation or infringement. Elevates the Supreme Court's role as the protector of the Constitution and ultimate interpreter of the law, serving as a catalyst for judicial activism and innovation. 3 categories of the urban local government: Nagar Panchayat for a transitional area, that is an area in transition from a rural to an urban area, municipality or municipal council for smaller urban areas, municipal corporation for a large urban area. Urban local bodies, a municipal corporation has three authorities: the council, the standing committee, and the commissioner. The council, comprising councillor, is the deliberative and legislative wing of the corporation that is headed by a mayor. He is assisted by a deputy mayor. Though the mayor is an ornamental figure, he is recognized as the first citizen of the city. The standing committee were created to facilitate the working of the council, which is too large in the size. The municipal commissioner is responsible for the implementation of the decision taken by the council and its standing committees. Indian cities largely follow the commissioners as chief executive CACE model as opposed to the directly elected executive mayor DEM model. DEM model, it is a strong mayor model where a mayor has extensive executive power. CACE model, it is a weak mayor model where the executive power lies in the hands of the commissioner, an Indian Administrative Service officer. Every state in the country has enacted legislation for the constitution of the municipality in the state specifying their functions, structure, resource, and their role in civic administration. Model Code of Conduct MCC. Why in the news? MCC comes into effect after ECI announced that country would vote in 7 phases from April 19 to June 1, and results will be announced on June 4. About MCC, it is set of guidelines laid down by ECI to govern conduct of political parties and candidates in run-up to an election to ensure free and fair elections. This is in keeping with Article 324 of the Constitution, which gives ECI power to supervise election to Parliament and state legislatures. It is operational from date that the election schedule is announced till date that results are announced. It is not enforceable by law, but some provisions are enforceable through corresponding provisions in statutes like Representative of People Act 1951, etc. Activities prohibited after implementation of MCC. Candidates cannot announce financial grants. Moreover, government cannot launch new projects. No promises from authorities related to infrastructure development like roads, etc. Prohibition of any ad hoc appointments in government or public undertakings. Ministers or candidates cannot sanction grants or payments from discretionary funds. Ban of government resources like transport, machinery, etc. for campaigning. Role of ECI in light of evolution of MCC. In 1960, MCC was first introduced in state assembly elections in Kerala. In 1974, ECI directed Chief Electoral Officer to constitute district level standing committee under which district collector keep check on MCC violation. In 1979, ECI added a section to regulate party in power and prevent it from gaining an unfair advantage during election. In 2013, Supreme Court in S. Subramaniam Balaji versus State of Tamil Nadu case directed ECI to include guidelines regarding election manifestos, which it had included in MCC. Other important news: registered unrecognized political parties RUPPs. The Election Commission of India ECI brought new rules new rules for the allocation of the symbols to RUPPs. The new rules mandate RUPPs to furnish the following along with the application for symbols: audited account for or of the last 3 financial years, expenditure statement of the last 2 elections. RUPPs are those which have not secured enough percentage of votes or seats in the last general elections to Legislative Assembly of any state to become a state party, or in the last general elections to Lok Sabha to become a national party. It also includes newly registered parties or parties that have never contested elections after being registered. ECI allots symbols to political parties under the Election Symbols Reservation and Allotment Order 1968. Internally displaced persons (IDP). Election Commission of India notified a scheme for internally displaced persons (IDPs) of Manipur to cast vote at relief camps in upcoming elections. It will facilitate voting facilities to the people who were displaced from their native places. IDPs are those forced to leave their homes due to armed conflict, violence, human rights violation, or disasters without crossing international borders. United Nations Higher Commission for Refugees. IDPs are those forced to leave their homes due to armed conflict, violence, human rights violations, or disasters without crossing international borders. United Nations High Commissioners for Refugees. It was a statement by this. Indelible ink, voters ink. Indelible ink, that is voters ink. Mysore Paints and Varnish Limited (MPVL), the sole manufacturer of indelible ink, received its largest order yet from Election Commission for 26.55 lakhs vials of marks or marker. Under Rule 49K of the Conduct of Election Rules 1961, every elector shall allow his left forefinger to be inspected by presiding officer or polling officer and an indelible ink mark to be put on it. Once applied, purple color ink cannot be removed by any chemical, detergent, soap or oil for several months. Ink contains silver nitrate, which on reaction with nail and on exposure to light gets darker. Ink contains silver nitrate, which on reaction with the nail and on exposure to the light gets darker. Nomination process. Nominations are filed under Section 33 of the Representation of the People Act 1951. Date of filing of the nomination is fixed by Election Commission of India. Candidate or any of his or her proposers should deliver the nomination paper to the returning officer (RO) or the assistant RO or to the assistant RO. Only an elector in the constituency in which the candidate contests the election can be proposed. On proposer is needed one proposer is needed for candidate from a recognized political party. 10 proposals are needed for independent candidates or candidates from registered unrecognized political party. Maximum 4 nomination papers can be filed by a candidate or on his behalf of a constituency. Nomination paper cannot be filed on holidays. Postal ballots. Election Commission has notified postal ballots for essential services workers. Postal ballots or vote by post allow eligible voters to exercise their franchise when they are unable to cast their votes in person. Eligible voters for postal ballots are service voters, member of armed forces, armed police force of a state, government employees, etc. Absentee voters, senior citizens, person with disability, etc. Electorals or electors on election duty or under preventive detention. Paper used in postal ballot is different from one used in the EVM. Thank you very much.